Hello friends, welcome to iExamB's Law Exam channel Legal B. Yesterday we discussed a situation where A had borrowed a car from his friend B, and while driving the car he reached a checkpost. At the checkpost, the police checked the back trunk of the car and found some illegal articles in the back trunk of the car which A was not aware of. So is A liable? And in another situation I asked you, A crossed a red light while driving the same car. Is A liable, and to which legal maxims these situations relate to? These two situations relate to two legal maxims. The first one is Ignorantia facti excusat, and the second one is Ignorantia juris non excusat. The word ignorantia here stands for ignorance. Excusat means excuse. Facti here stands for the word fact, and juris deals with the word law, like obtained from the word jury. The meaning of these legal maxims is ignorance of a fact is an excuse. Now in our first example, the situation was he had borrowed the car from his friend and he did not know what was there in the back trunk of the car. So this is a fact, and ignorance of a fact can be an excuse, and hence he may not be criminally liable. In the second situation, A had crossed a red light. This is a law. Everyone knows that a person should not jump a red light. Thus, the second legal maxim pertains to ignorance of law is not an excuse. While ignorance of fact can be an excuse, ignorance of law cannot be an excuse. These maxims are incorporated in section 76 and 79 of IPC. These sections are a part of general exceptions of IPC. Section 76 says act done by a person bound by mistake of fact, believing himself bound by law. So it says nothing is an offense which is done by a person who is or who by reason of a mistake of fact and not by reason of mistake of law. मतलब किसी mistake of fact में good faith में एक person ये believe करता है that he is bound by law to do it, then in that case that act will not be considered an offense. There are two illustrations also given. The first one is, let's go through the first illustration. A soldier fires on a mob by the order of his superior officer in conformity with the commands of law. A has committed no offense. क्यों? क्योंकि A ने यहाँ पर ये समझा है that he is bound by law to do it. By order of his superior officer he is bound, and thus he has not committed any offense. The second example pertains to mistake of fact. Here A is an officer of the court of justice who has been ordered by the court to arrest Y. And after due inquiry, मतलब उसने अच्छे से inquire किया है, he believed Z to be Y and arrests Z. So here a mistake of fact is there. In good faith, उसने पूरी inquiry निकलवाई थी and then he realized, then he believed that Z ही Y है and Z को arrest कर लेता है. A has committed no offense. So mistake of fact can be taken as an excuse, can be taken as an exception, but mistake of law cannot be taken as an exception. Let's understand this with a very simple example. A and B are two persons who are sitting together and working on a project. Both of them has the same pen. Now after completing the project, A picks up a pen and goes to his house. That pen belonged to B. But since both the pen were similar, here A had a mistake of fact. So here A has not said to be committed the offense of theft, क्योंकि दोनों pen same थे. Now coming to section 79 of IPC. Section 79 of IPC says act done by a person justified or by mistake of fact believing himself justified by law. So it says nothing is an offense which is done by any person who is either justified by law or who by reason of mistake of fact and not by reason of mistake of law. तो mistake of law तो कभी excuse लिया ही नहीं जा सकता. Ignorance of law is not an excuse. Again, in good faith believes himself to be justified in law in doing it. Let's go through the illustration. A sees Z commit what appears to A to be a murder. A in the exercise to the best of his judgment exerted in good faith of the power which the law gives to all persons of apprehending murders in the fact seizes Z in order to bring Z before the proper authorities. So A has committed no offense, though it may turn out that Z was acting in self-defense. Even बाद में पता चले कि Z self-defense में act कर रहा था. Here A has acted in good faith. First thing. Second, A had a mistake of fact. उसको लग रहा था कि एक murder होने वाला है. Even though Z was acting in self-defense. तो उसे self-defense का idea नहीं था. यहाँ पर उसे mistake of fact लगी. Hence, the offense of seizing Z can be excused. Ignorance of fact can be excused. There are some very important case laws which are related to this maxim. The first one is State of Maharashtra versus Mayor Hans George, also called as M.H. George case. In this case, the Supreme Court upheld the validity of the doctrine in Indian context. The validity of the doctrine, Ignorantia juris non excusat. Ignorance of law is not an excuse. अब इस केस में क्या हुआ था, 24 नवंबर को गवर्नमेंट ने एक ऑर्डर पास किया था रिस्ट्रिक्टिंग द ट्रांजिट ऑफ गोल्ड आउटसाइड द टेरिटरी ऑफ इंडिया सो दैट दे कैन कंजर्व देयर फॉरेन एक्सचेंज टू प्रिवेंट द स्मगलिंग. M.H. George was a German national who had boarded a plane from Zurich to Manila. There was a stopover at Bombay, जहां पर M.H. George को अरेस्ट कर लिया था for carrying 34 kilograms of gold. Foreign Exchange Regulation Act के अंडर he was held liable. Trial court has convicted M.H. George. Later High Court has acquitted M.H. George. Later Supreme Court held him guilty and said that ignorance cannot be held as an excuse in cases of law. A person is bound to know the law. But in this case, there were certain discussions between the justices. First view was observed that knowledge of law is not relevant except the issue of sentence to be imposed is being discussed. Though the judgment was passed against M.H. George, Justice Rao in this case wanted to include the reasonable person test. That means if a law is not published in the Gazette, if any person does not know about the law, then how could that person follow law? Again, later in the Law Commission report by Narasimhan, due diligence test was suggested to be included, which also gave the idea that the law must be available in the public domain in order to follow this maxim. Ignorance of law cannot be excused. This is possible only when the law is known to the public. Then there is another case law which is Universal Cans and Containers Limited versus Union of India. In this case, the court held that the doctrine is applicable not when the law is printed in the official gazette, but when it is made available to the public. For civil and criminal matters, there are different stands with respect to this doctrine. In civil matters, the applicability of the doctrine has been questioned in few case laws. In Subhashish Mondal versus Union of India, delay in the contravention of law was condoned due to the lack of legal awareness in the rural areas. In another case of Tanaji Abbaso Pawar versus State of Maharashtra, the Bombay High Court accounted for the prevailing illiteracy and bureaucratic red tapeism and refused to apply the doctrine because otherwise it would encourage predatory behavior by the government. So, the legal maxim ignorantia juris non excusat will not be applicable. But in criminal matters, the courts have to be a little bit cautious because slight relaxation of the doctrine in criminal law, especially for the crimes mala in se. Mala in se means the crimes against the morals, against the natural tendency, like murder. They can have disastrous repercussions because a person morally knows that he should not kill another person. So in criminal matters, courts have to be cautious while applying this doctrine. It was also mentioned that if a person is oblivious about what constitutes a criminal offense, it promotes criminal behavior. For example, rape by deception. Now, over the time period, the definition of consent in case of sexual offences have widened its scope, have been elaborated by courts from time to time. Now, if a person is oblivious to this fact, if he does not know what changes have been brought in the definition of consent, and a man is deceiving a woman by giving promise of marriage for the purpose of entering into sexual intercourse with the woman, then the man should know that the consent which has been obtained by deceiving is a crime. This was observed in Anand P. Chanar versus State of Maharashtra, and it was stated, ignorance of law stemming from the dearth of legal education. So if the person does not even know whether it will be a crime or not, then also criminal behavior may rise. Also, in state of Orisha versus Khodaghasi, the accused, while guarding his field, shot an arrow on the moving object in good faith that it was a bear, but the shot results in the death of person. Here he gets the immunity under the mistake of fact, because it was a mistake that he assumed the man to be a bear. In another case of Grant versus Borg, the person was charged under Immigration Act 1971 because he stayed beyond the time limit by the leave. And here he cannot apply for the defense of mistake of law, because he might know by law when his immigration certificate will be expiring, when he should be leaving the country. So that is a law of the country and he cannot apply for the defense. We have discussed about mistake of law, mistake of fact. Now let's discuss another situation. A is a person who is walking on the road. Another person, B, approaches A and shows a gun to A and asks A to hand over his purse. A pushes B and runs away. While A pushed B, B fell on the road and his head hit a rock and B died on spot. Now, will A be liable? Under which legal maxim this situation relates to? At iExamB, we help you prepare for a lot of law exams. iExamB is your one-stop solution for all the legal exams preparation. We have banking law officer, insurance law officer, legal officer, Coal India, banking law officer for Scale 2, and regulatory bodies law officer exam preparation online courses. If you are interested, visit the demo course from the description below. You can write your queries to us at hello@iexamb.com. You can call us on the number mentioned on the screen. Subscribe to our Legal B channel to stay tuned with such important legal information, legal news, legal exam notifications. Thank you.